Good evening and welcome to this 5 St Andrews Hill seminar on the new sentencing code and demystifying risk assessments in Precenter Reports. Can I start by expressing our collective thanks to the LCCSA for helping us to promote this event, and thank you to anybody who's joined through LCCSA. Can I also thank Judge Ed Connell, who joins us to give his views on each of the topics that Amy and I will talk about. We'll talk about, in my section, Precenter Reports, and in particular the risk assessments that are carried out. And really my part came about as a result of a sentencing hearing that I did at Reading Crown Court earlier this year. And I'll talk more about that when we come to the RM 2000 section of my talk. But the purpose really is to give you an introduction and overview of the tools that are used by the Probation Service, how the information is gathered, and what you can do to address some of the conclusions that are come to by the authors. And hopefully by understanding some of the process and how it operates, you can advise your clients and prepare your mitigation accordingly. So my first slide, just an overview of what Precenter Reports address. We're all familiar with them, but they're the principal topics which, for the most part, come about as a result of questions asked from an offender, both in the form of an interview and also from a self-assessment questionnaire. The sections themselves, the contents speak for themselves, and so I'm not going to go into any detail about them, but just be aware that some of the information contained in those sections is used by the Probation Service when they do their risk assessments. Can I have the next slide, please? The tool that's used by the Probation Service in all reports is called the Offender Management System, or OASIS for short, and you will have seen it on reports that you've had. And the purpose is, when it was created, are set out on the slide here, how to, assessing how likely an offender is to reoffend, one of my principal topics. And the other one I'll talk about is the assessment of risk of serious harm. But of course it does address all the other points in there. It should be noted that in relation to all the tools that I'm about to talk about, they're all actuarial as far as risk of serious harm is concerned, risk of reoffending is concerned, sorry. But some research has indicated that the predictive value of some of these tools doesn't properly take into account things like Black and ethnic minority groups. But there are at the moment no plans to introduce additional sections into any of these assessment tools in order to address that factor. I mentioned that in passing, but I'll come back to it at the end. But the first one I want to talk about on the next slide, please, is the risk assessments themselves. They use both dynamic and static factors. By dynamic, we're talking about things like education, employment, living arrangements, relationships. And the static factors that can't be changed by the author or by the offender: age, sex, number of previous convictions, to name a few. And the tools themselves have different names. Again, you will have come up with them, come across them probably with the acronyms: the Offender Group Reconviction Scale, Risk of Serious Recidivism, RM 2000, and they're the three that I'm going to talk about. But there are others: the Spousal Assault Risk Assessment and the OASIS Self-Contained Sexual Reoffending Predictor. I'll not talk about the last two because they're less common, but you may find additional information online about them. And of course, the risk of serious harm assessment, a separate and standalone assessment conducted by a probation officer. So if we can go to the next slide, please. The risk of serious harm, dealing with that one first, now contained in the Sentencing Act 2020 is the test, as it were, that the court considers, specifically whether there's a risk of death or serious personal injury, whether physical or psychological. That's what amounts to serious harm. Whereas the OASIS system uses a slightly different one, being an event which is life-threatening and or traumatic, from which recovery, whether physical or psychological, can be expected to be difficult or impossible. So it's a slightly different test applied by the Probation Service, but they are quite close, you may think. For example, a traumatic event, used in this OASIS definition, might cause serious personal psychological injury, which links back to the Sentencing Act definition. But it is an added consideration. The difficult or impossible to recover from element is applied only by the Probation Service. Next slide, please. The risk of serious harm tool is an assessment which is clinical rather than actuarial. And what I mean by that is it's not based on statistics gathered from research, it's based on the interviews and the answers that are given to the questions in the interview. And really an assessment conducted by a trained probation officer as to whether or not they think a person presents a low, medium, high or very high risk of serious harm. They're most likely encountered when the court itself is looking at a dangerousness assessment, but they can be included in all reports. The initial stage is a screening, when the probation officer decides whether or not a full analysis needs to be done. If the answer is no, of course, it stops there, and it probably won't appear in the probation report. But if they do, the probation officers look at what the risk is and who is at risk, whether children, adults, public staff, or the offender, him or herself. And it draws together information from all the sections of the pre-sentence report, which you saw on the first slide, in addition to the answers to questions that are asked. You should, when you have a risk of serious harm assessment, have all the information that's been relied upon by the author within the pre-sentence report sections or within the risk assessment itself. But the author might not, for example, have psychiatric reports, psychological reports, or medical reports. And so there's some of the things that you might want to address a judge on when it comes to that risk assessment. But I think what should be encouraged is that you make any reports that you do have available to the probation officer, so that when they're making their assessment, they can take into account whatever it is that you have. Not only is it likely to be more helpful for your client, it's certainly going to be much more helpful for a judge. Can we go to the next slide, I think, please? Yes. So the risk levels are low, medium, high, and very high. I'll not read out the definitions of what they mean. You have them on the screen as I talk. But anybody who is high or very high risk and then becomes subject to any sort of probation supervision would be managed by the Probation Service itself, whereas anybody on low or medium risk would then be supervised by a community rehabilitation company, or the CRCs, which was set up a few years ago. Next slide, please. Moving on to the risk of reoffending, which is a separate assessment. These are all actuarial, so they are they use statistics gathered from research conducted often over long periods of time. And they're an actuarial prediction of proven reoffending. And what that means is any sanction, whether that's a sentence at court or a caution or warning issued to juvenile offenders. And they look at the risk of reoffending within a 2-year period from release from prison or from the date of the imposition of a community order or a community-based order. And they look at age, gender, the current offence type, and criminal history. So again, these static factors, meaning that once you get your outcome, you get your level of risk at the end of it, you might be able to address that by looking at the dynamic factors that you have within your instructions or within the pre-sentence report itself to address the court on reconviction risk. Turn to the risk of serious recidivism, a word I always struggle to get my tongue around. Again, is an actuarial prediction of proven reoffending, something that's common through most of these assessments. And it, in this case, uses static and dynamic factors. Specifically, dynamic factors here are accommodation, drug use, and employment. There used to be an assessment of a person's alcohol use, but that was found to be a low predictor or a low reliability, and so it was removed from this type of assessment. But the indication is of somebody committing a seriously harmful offence within that 2-year period. And I've put at the bottom there just a list of some, but not all, of the types of offences that the author will have in mind when looking at a seriously harmful offence, a murder GBH, all the way down to, on the list, down to aggravated residential burglary. Turning to the RSR scoring on the next slide, please. There are 3 sub-scores that make up the RSR final score listed there. The most common that you will come across is likely to be the non-sexual violence, and your report is likely to focus only on that and not the others, because contact sexual offending and indecent image assessments are only conducted for adult males who do have a history of sexual offending. So if you're representing someone for an ABH, it will not have considered those factors. It will only look at non-sexual violence. In passing, the first 2, the contact sexual reoffending and indecent images, are more specific and more targeted. The contact sexual offending uses an offender's sexual offending history and age, and then comes up with a prediction in a year's time or 2 years' time as to risk. And the indecent image assessment is based solely on the offender's sexual offence history. So quite targeted, but again, not going to apply to every report that looks at RSR. But the non-sexual violence is much more complicated, uses different risk factors, again, drawing on some of the factors contained within the body of the pre-sentence report. One thing to remember broadly about the ones I've just mentioned, and indeed all of them, is that they're all stats-based. So that's something that you need to bear in mind when you're addressing the court about the level of risk. These are based on information gathered from large numbers of people. They're not specific to your individual offender, and you can tailor your mitigation accordingly. Dealing lastly with RM2000, there are different iterations of RM2000. One deals with sexual offending, another deals with violent offending, and there is one as well for general offending. But you're more likely to come across it with sexual offending because some of the other assessment tools will point the probation officer to the RM2000 assessment and encourage them to complete one. It was created at the beginning of the 2000s by David Thornton. He published a paper in 2007, which you can find online if you want to read more information about it. But this, again, uses only static factors relating to the offender and the offence in order to come up with a risk of reoffending. The data itself, some of it is almost, I've put now 20 years old, but in fact it's almost 20 years old. I think the most recent data that's used is up to 2003. And it was gathered from offenders who were assessed from the 1980s and 1990s and followed up once they were released from whatever sentence they'd received. It's recognised that it has a moderate predictive value. So it's by no means set in stone, and of course it's a prediction. There are 4 levels, levels 1 to 4, 1 being low. And in terms of definitions, they're not very clearly defined in the paper, but high, according to Professor Thornton, means sufficiently high to be worth worrying about, whereas low and medium don't carry a definition at all. But just to give you an idea of what they mean statistically, low and medium, if I'll take them in turn, but within a period of 5 years, the research found that if somebody was a low risk, there was an 8% chance of them committing a further offence within a 5-year period. Medium was 25%, high 49%, and very high an 85% chance. Although I've just mentioned reconviction rates within 5 years, what you typically find in the report is a prediction for risk of reoffending within 1 year or within 2 years, sometimes within 5. If we go to the next slide, please. These are the factors that are taken, the only factors that are taken into account for the assessment. The age at commencement of risk, sexual appearances, criminal appearances. Now, those 3 factors fall within the first, there are 2 stages, they fall within the first stage and they're scored, and the score gives a risk level. The next 4, sexual offending against a male, sexual offending against a stranger, whether the offender is single, and whether or not the offence was a contact or non-contact offence, are considered aggravating factors, and again, they're scored individually, and the overall level will be influenced by the outcome of that second section. Just to illustrate this, the case that I dealt with that I mentioned at the beginning at Reading Crown Court was a case in which the offender, it was a sexual assault against a minor, was assessed using RM 2000, and he was placed at a high risk of reoffending. And when I looked into the body of the pre-sentence report, it was apparent that the author had concluded that the victim, not complaining because there wasn't a statement, she was very young, but the complainant, the victim was not known to the offender. He was a carer, in effect, assisting his mother, who was a registered child minder. And he'd said to the author of the pre-sentence report he didn't really know the victim. But in my instructions, it transpired that actually he did know her. He had worked with her previously, he'd cared for her with his mother. And so it affected by 1 point that question of whether or not it was a sexual offence against a stranger. But the effect of it was to bring him down from high risk to medium risk. This is just a reminder that high risk being a 49% risk of reconviction down to a 25% risk of reconviction just on that single factor alone. So when you delve into these individual questions and you check the information in the pre-sentence report, you might find some argument about the accuracy of the assessment itself. Can we turn to the next and I think last slide, please? In conclusion, I hope I've given you a flavour of some of the limitations of the risk assessments, namely that apart from the risk of serious harm, they're actuarial based on large numbers of people and not geared specifically to individuals. The risk of serious harm, of course, is based on the experience of the assessor. And there is some research to suggest that the same offenders assessed by different probation officers will result in a report finding a different level of risk. I wouldn't suggest you go into court and start criticising the experience of a probation officer because they all are very well trained. But it is something to bear in mind when sifting through the information and making an assessment of how closely the the report itself reflects the instructions that you have. And tied in with that, it's good to take additional instructions on those dynamic factors that might influence a judge. So, for example, these assessment tools, being based on risk, don't take into account other positive things. For example, your client having enrolled at college, his or her having moved house and been taken into a different environment, or even winning the lottery. So there may be something in your instructions that, despite what is in the pre-sentence report, could have a bearing on the final sentence, even if it doesn't affect the assessments themselves. and those factors that you have in your instructions can be powerful mitigation. I'm going to pause there and hand over to Judge Connell, who will give us a little bit of an overview from his perspective of pre-sentence reports.
Well done, first of all, to John for trying to demystify the world of risk assessment. I suspect that many people watching this evening, like myself, are used to seeing these assessments in the pre-sentence report, but not really understanding how the conclusions have been reached and what sorts of factors and criteria have been taken into account. And unless you're armed with that knowledge, it's impossible to make any meaningful observations about the reliability of the assessment when addressing the judge. All pre-sentence reports contain risk assessments, but in my view, the cases where the assessment has the most significance is in those cases where the court has to consider dangerousness. Let me just deal firstly and briefly with cases which don't attract the dangerousness provisions. My view is that in those cases, the risk assessment from probation is much less influential. And there are two reasons for that. The first is most assessments in non-dangerous cases tend to be based more on static and therefore less reliable factors. And secondly, the facts, the mitigation and the sentencing guidelines will largely determine the appropriate sentence in any case. And the risk assessment performed by the Probation Service is unlikely to change the judge's mind as to the appropriate disposal in your particular case. If you are looking though at a case on the custody threshold or one that is capable of suspension, I would expect a judge to be more influenced by factors such as the defendant's previous convictions or his performance on previous community orders and the prospects of whether or not he can be rehabilitated, rather than by the Probation Service's assessment as to risk. As for dangerous offenders, I think that dangerous offenders tend to fall into two categories. The first category, where it's blindingly obvious to the advocates and the judge that the defendant is dangerous, and so clear is it the judge may not even feel the need to obtain a dangerousness assessment. And then the more difficult category, where it's less clear-cut. And I think it's in the less clear-cut cases where the assessment performed by the Probation Service is much more persuasive on the court. The assessment of dangerousness is largely dictated by the nature and seriousness of the index offence, combined with the defendant's previous convictions. However, the authorities on dangerousness make it clear that in all but the clearest of cases, the usual course will be for the judge to adjourn specifically for a dangerousness assessment to be performed by the Probation Service. Now, that's not to say the judge will always follow the recommendation of the report, because we don't. But bear in mind that if the judge is going to go against the recommendation, he or she is going to have to justify that decision, as the Act specifies that the assessment is an evidence/information-based decision, and the probation assessment is an important part of the information available to the court. The case law, particularly the leading case of Lang, has reinforced the significance of the Probation Service assessment. The defendant is now going to serve 2/3 of that sentence before being released on licence, rather than the halfway stage as was previously the case. That makes a big difference to time spent by a prisoner in prison. And so that is a factor you want to remind the judge about, as it may help you tip the balance in favour of a determinate rather than a dangerousness disposal. Secondly, if you think you have the grounds to challenge a risk dangerousness assessment, as John did in the cases just described to us, then don't be afraid to take that up with probation before the hearing to find out whether the information you have is going to make a material difference. And if it will make a difference, then don't be afraid to say to the judge, if you are considering a dangerous determination, I'm going to seek a reassessment for this reason. And the judge, if he thinks it's going to actually make a difference, will be prepared to do that. And finally, in cases where there has been an assessment the defendant is likely to reoffend, but where there has been a significant gap between the offending and the sentence, as will be increasingly the case, I suspect, over the next couple of years as a result of the pandemic, then be sure to bring that to the judge's attention, as it will undermine any dangerousness assessment. I'm now going to hand over to Amy Woolfson, who's going to talk to you about the new sentencing code.
Thank you very much, Judge Connell. I'm going to be talking about the Sentencing Code, which is now also known as the Sentencing Act. If I could, my name's Amy Woolfson. I'm a barrister at 5 St Andrews Hill. Before I came to 5 St Andrews Hill, I worked on the criminal team at the Law Commission, albeit not on the Sentencing Code project itself. I also worked in politics for about 5 years before I came to the bar. If we could go to the first slide, please. So what I'm going to do with this talk is give you a whistle-stop tour of the Sentencing Code, what it does, what it doesn't do, and a couple of thoughts for the future of sentencing law and procedure. So the background to the Sentencing Code, it was a project of the Law Commission. They wanted to address the fact that sentencing law and procedure was scattered across a huge range of statutes, going back all the way to the Justices of the Peace Act of 1361, and going all the way up to Acts of Parliament which are yet to be fully commenced, such as the Offensive Weapons Act of 2019. The huge range of sentencing legislation and also the way in which it is commenced meant that there were all these layers of sentencing law, and it could become incredibly difficult to identify exactly what applied to a person being sentenced at any particular time. A couple of examples, Banks, the editor of Banks on Sentence, examined 500 Court of Appeal cases in 2012, just looking at whether the sentences that had been passed were correct in law, not whether they were unduly lenient, manifestly excessive, but just whether the correct powers had been used. And of 262 cases that he examined, he managed to find 95 where the sentence was actually wrong in law. That's over a third. Two very quick examples. Court of Appeal case of GJD, a man who was given a sentence of imprisonment for public protection in 2006. In 2015, the Court of Appeal identified that actually when he'd been sentenced, the sentencing court did not have the power to give him a sentence of imprisonment for public protection because his offence had been committed just before the provisions in the Criminal Justice Act 2003 had been commenced. Similarly, there was a case of JM, which was an Attorney General's reference in 2017. It was a case where a non-recent sexual offence and the defendant was given a community order, which the Attorney General said was unduly lenient. When the Court of Appeal looked at it, it turned out that given the date of the offence, there was no power to give this man a community order at all. Back in 2000, we had the Powers of Criminal Court Sentencing Act, which was meant to consolidate a lot of sentencing law, and that itself was a Law Commission project. The problem was it was very quickly undermined by more legislation, in particular the Criminal Justice Act 2003. The Law Commission's response to the failure of the PCCSA is essentially go big or go home. They decided to embark on a much more ambitious project, which is the Sentencing Act, and they've also worked on it in a way to try and make it future-proof. The Law Commission have done a fantastic job to get this to where it is, and they built a huge amount of consensus in practitioners and the judiciary, and frankly, just as an exercise in how to get everybody behind a project, it's really remarkable. If I could have the next slide then, please. So the Sentencing Act applies to all defendants convicted after the 1st of December 2020. The flip side of that is if you have a defendant who was convicted before that date, then the law that applied before that date still applies. So if you have someone who's pleaded guilty and they've been committed for sentence, if they pleaded guilty before the 1st of December, you need to look to the old law. And what it provides is a really comprehensive and logical structure for sentencing, and in a very innovative way. It contains signposts, which are really a new feature. So where the Act itself doesn't contain the law that you need, it will point out where the law you need can be found. So one example of that is disqualification of company directors, which is not part of the Act. But there is a provision there under the disqualification section which says you need to go and look at the Company Directors Disqualification Act 1986. It also has a home for uncommenced provisions, the idea being that if something has been put into law, for example, with the Offensive Weapons Act, there's a new mandatory minimum for repeat corrosive substances offences, but it's not taken effect yet. That's currently nestled, as it were, in a schedule to the Act, the idea being that once it is commenced, it can be brought into the main Act. It also has much more modern language. So instead of talking about an offence for which the sentence is fixed by law, it says murder, because that is the only offence for which a sentence is fixed by law. So really, in my view, it's an Act that's designed to contain everything that a sentencing judge needs in order to sentence a person. Does that mean that it contains everything a defence practitioner needs? I would say it largely does, and I'll discuss that in a bit more detail shortly. So if I could have the next slide, please. This is a summary of what the Act does not do. So as I've already explained, it doesn't apply to convictions before the 1st of December. It also doesn't apply to the resentencing of offenders convicted before the 1st of December. So if you had a case in the Court of Appeal and the defendant needed to be resentenced, it wouldn't apply to them. It doesn't apply to breaches of a community order, for example, that's been imposed prior to the code. And it also leaves untouched some areas which the Law Commission considered were self-contained sentencing regimes. So, for example, disqualification under the Road Traffic Offenders Act. The Law Commission's view was it was a self-contained system there, and it didn't necessarily need to be moved into the main Act. With that point on self-contained codes, in my view, it follows a bit better for something like company directors disqualification. You can be disqualified from being a company director for reasons other than criminal offences. Perhaps with the Road Traffic Offenders Act, the clue's really in the name, it deals with offenders. You might think that logic doesn't follow quite so strongly. What it also does not do is deal with anything to do with release of offenders, supervision, recall. So it's not going to help you advise your client or their family about when they might be released from prison and on what terms. Academically, that's for a very sound reason, which is the Law Commission looked to the Court of Appeal, who have said these aren't things a judge is meant to take into account generally when passing sentence. And as I say, academically, that's a very sound reason. But as a defence practitioner, it's something you often want to know. There are also a couple of exceptions in the code which have had to be made so that it's compliant with Article 7 of the European Convention on Human Rights, which states that you shouldn't be subject to a greater punishment retrospectively. So one example of this is surcharges. Victim surcharge was introduced in April 2007, and it's gone up and up and up. If you were going to start sentencing people for historic offences with a victim surcharge at today's rates, that could offend Article 7. It might not be a huge amount of money, but it does offend the principle. So that's an example of where it doesn't apply. if I could have the next slide, please, Tess. Thank you. So what I'm going to do now is give you a very brief guided tour of the Sentencing Act itself, and just take you to a few of its really interesting features. So I'm going to share my screen. Okay, so this is the Sentencing Act. It's all there on the legislation.gov.uk website. You can see the overall structure. It's been designed to follow the sentencing process in a chronological order. So it starts off, as all Acts of Parliament do, explaining the introduction, but then it moves into things like committal, and then it goes into aggravating and mitigating factors, the statutory purposes of sentencing, and then it sets out the range of disposals, moving from an absolute discharge up here down to your custodial sentencing, and further powers. And as an example of one of these signposts, if we go to disqualification, so you can see here, you've got your so this is section 170 of the Sentencing Act, and it's effectively a signpost, because what it says is if you need to look at disqualification for drivers, don't forget that in addition to the powers that are set out in the Sentencing Act to disqualify a driver, so these powers here, you also might need to go and take a look at the Road Traffic Offenders Act. So it's not containing any law as such, it's a signpost. What it also does is useful things like grouping together things that obviously should go together, such as offences where there's a mandatory minimum. So if you look in the custodial sentences, you have all your minimum sentences for different types of offence. And going back to what I was telling you about offensive weapons, if you look at Schedule 22 of this Act, which is the home for uncommenced provisions, you will find ready and waiting to go some provisions to then paste into that section, so that again everything you have is all still in that place. There's also some nice features. For example, if you're looking at imposing a sentence for murder, as I said, it says murder rather than fixed by law, and it's Schedule 21, which is also where you were with the Criminal Justice Act 2003. That was also Schedule 21 for murder. One thing I'd point out as well, if you ever get lost in the Sentencing Act and you think, well, I always knew where it was in the PCCSA or whatever, or if you're dealing with one of those old cases where the law's not been, you need to go back to the old law, what you can do is go and take a look at the table of origins and destinations, which is here. So if you find yourself thinking, gosh, I wonder what happened to section 227B of the Criminal Justice Act, you can go in there and it will show you where it's been taken to. Tess, I wonder if you could go back to my slides, please. I think I have to stop sharing. So how it will make a difference? Well, it brings structure and clarity to the sentencing process, where it's become quite frayed up until now. in terms of historical offending, it makes it very clear that you just apply the law as it is in the statute. Today, you don't need to think, well, if it was 2005, was that before you could attach a condition to a suspended sentence or not? Was the sentence lawful to pass? It's all there. So there should be less of these quite disturbing mistakes of the sort that I've taken you to in my examples just now. And the really good thing about it is it frees up your time as an advocate, rather than having to wade through various provisions to enable you to help the court identify the correct law. You can actually just focus on getting your mitigation together. So that's in my submission a really big advantage for practitioners. It also sets out all the powers essentially of the court in one place. So hopefully it should encourage the use of all of those powers. You see that deferred sentences are on the, I think it's section 3 of the Act. So right up at the top, front and centre. And I think that's really interesting. In the recent white paper on sentencing, which was back in September, under the heading deferred sentencing, they said, we will encourage courts to use existing legislation. So it's really setting out and hopefully allowing us as practitioners to remind the court of their full range of powers to deal with the offender in the right way. I'm just going to give you a very quick example of how much easier it is to find out what the court's powers are, based on a case that I dealt with actually just yesterday, where we were sentencing a defendant for a second weapons offence, and we had to consider the mandatory minimum. Okay, so we were sentencing, I was representing a lady who'd been convicted of a second bladed article offence. So that's section 139 of the Criminal Justice Act. And the first bladed article offence had happened an awfully long time ago. And the question in court was, oh, does this engage the mandatory minimum? So pre the 1st of December, what you would need to do is take a look at section 139 of the Criminal Justice Act 1988, and you can see, right, okay, 139(6) capital A, where a person is convicted after this subsection is commenced and they had at least one relevant conviction, then you need to impose a mandatory minimum unless it's unjust to do so. Okay, well, when was this subsection commenced? Well, to find out that, you follow the little note F3, and that tells you that it was inserted by the Criminal Justice and Courts Act, but you don't want to look at the Act, you want to look at the statutory instrument that commenced it. So let's go and have a look at that. Right, okay, 17th of July. So has my defendant been convicted after the 17th of July? Well, yes, she was convicted yesterday. Okay, so that's check. You then need to see what are the other relevant convictions. Well, let's see. It says see section 139 AZA, the Criminal Justice Act. So we'll go have a look at that, and it tells you what a relevant conviction means. And then what it says is, well, it's a conviction under this Act, or the Prevention of Crime Act 1953. Well, we know as practitioners that that's an offensive weapon offence, but there's nothing in the title of the Prevention of Crime Act to really give you any clue as to that. So you might want to then go and check the Prevention of Crime Act. Okay, right, that's offensive weapons. So you then work your way all the way back to the Criminal Justice Act 1988 and start thinking about, okay, yes, this does apply to my client. Under the Sentencing Act, you go to minimum sentences. So it's minimum sentence for repeat offence involving weapon or bladed article. Hopefully it will load. You take a look at it. A lot of the language is very similar. But what it says is an index offence, okay, having a blade or article in a public place. After 17th of July 2015, well, that's a lot easier than going and looking up a commencement provision. And it also points out, it gives you a clue as to what Section 1 of the Prevention of Crime Act is all about, because it gives you a short description. So it's just much clearer, much more user-friendly drafting, which will hopefully save us all a lot of time. I'm going to stop sharing now, and Tess, if we could just go back into my slides. And if we could just have the next slide, please. So the future, well, the drafters of the Sentencing Code have worked really hard to future-proof the legislation so that it doesn't go by the wayside in the way that the Powers of Criminal Court Sentencing Act did 20 years ago. The Sentencing Act is really a great piece of legislation. It's a lot more user-friendly. It's a lot easier to find your way around it. But it is really out of their hands now in terms of the drafters and the Law Commission. It's over to the politicians now. And what I would say is that nobody set out for sentencing law and procedure to be a big, horrible mess. It didn't happen overnight. It happened in a piecemeal fashion. And while the current generation of politicians are committed to the Sentencing Act, and again, that's a great credit to the work that the Law Commission did, you know, time passes, people's memories fade, and other things become more pressing. You can imagine a new Lord Chancellor, maybe one that's not a lawyer, bringing in some major sentencing legislation and just thinking, well, I know what I want to do, and I don't want to bother myself with fitting it into the confines of the Sentencing Act. There's also a couple of issues. You've heard about the exception the Law Commission made for self-contained statutory schemes. The logic's very good, but at the same time, it is a bit of a matter of opinion whether something's a self-contained statutory scheme or not. You can imagine some new terrorism legislation, for example, coming in with new offences, new civil powers, new sentencing powers, and someone saying, well, I mean, really it is a self-contained statutory scheme, therefore we won't amend the Sentencing Act. So my prediction is that it will remain largely intact for a while, but it is really inevitable in my view that it will be nibbled at over time and will lose some of its coherence. But in conclusion, it's a really welcome, useful and helpful piece of legislation that should hopefully make advocates' lives quite a lot easier and allow us to focus on the really key issue, which is getting your client's mitigation out there in the best possible way. Thank you.
Well, I don't have very much to add to the excellent overview that Amy's just provided us with, not least because the court hasn't really had an opportunity yet to see how the code works in practice, bearing in mind, as Amy said, that it only came into force for convictions dated after the 1st of December this year. But I just wanted to make a few general observations, 5 in fact, about the code, and then a couple of very brief observations about sentencing in the pandemic. General perspective, first of all. As Amy said, the driving force behind this act or code was to simplify and streamline sentencing procedure and hopefully make life easier for judges. That's why it's judge orientated, and that's why, for example, you don't find things in there such as release provisions for prisoners, because that's not something a judge has to worry about. As Amy said, the cost of judges passing unlawful sentences, which then require correction either by the Crown Court or the Court of Appeal, is significant. It's anticipated that this sentencing code, if successful, will save up to £250 million over the next 10 years. And that's because magistrates and judges will be getting it right, hopefully, first time around. The second point is that the code doesn't make any changes to the maximum sentences for any offences. The maximum sentences for most offences are contained within the statute that creates the criminal offence, and that will not change. So what that means is, if before the code your lay client should have got a sentence of perhaps 3.5 years, then the sentence your lay client should be getting after the code should still be 3.5 years. Thirdly, Newton hearings, Underwood hearings and Goodyear applications are still good law, but they're not contained within the code. And that's because they are procedural matters that derive from case law. And to have incorporated them into the code would have been to create new law, which was not the purpose of the code. The code is to consolidate rather than to create. Fourthly, sentencing guidelines still apply in exactly the same way as before. And I would urge you, if you don't already access them from the Sentencing Guideline Council website, to do so, because they're kept up to date there. But you'll notice if you've been there recently, since the 1st December, that their website has been updated so as to include references to the code. And I also believe that Banks on Sentence, if it hasn't already, is going to be adapted to incorporate the code. And there is being drafted at the moment a Crown Court Compendium on Sentence to again incorporate the code provisions. And finally, the code, as Amy has said, is a living document. Any new sentencing procedures should automatically be included in the online version of the code as soon as it becomes law. So her example she gave with the minimum sentences for corrosive substances when it does become law should move seamlessly from the schedule into the code itself. I say should because those of you who've read the Secret Barrister's more recent book, Fake Law, talk about how there's still a significant percentage of laws on the official government website which are not up to date, but one would hope that one as important as this would be kept up to date. So make sure you're always using the online version of the code rather than any printed provisions, so you're always aware whether you're up to date or not. And finally, very quickly, as we're talking about sentencing and we're in the middle still of the pandemic, just a couple of quick specific matters with regard to how to approach sentencing in the current environment. As you all know, we are trying to conduct more and more hearings via CVP for the convenience of counsel and defendants. The demand for those hearings is high, but we're limited by the slots we're given by the prison, which in turn limits the number of defendants we can deal with. That means that most hearings, particularly sentencing hearings, are being shoehorned into 30-minute time slots. That's not a lot of time when you spend 10 minutes trying to get someone's microphone to work, then have the prosecution open the facts, then mitigation. And whereas before the judge would have had the luxury of retiring to consider submissions and draft their sentencing remarks, those will have to be done there and then, which is precisely the sort of environment where errors that the code is designed to eliminate occur. So I would urge you to do two things. Firstly, feel free, whether you prosecute or defend, to upload sentencing notes onto the DCS before the hearing. The judge will have the opportunity then to read those and save some valuable time in court. They needn't be lengthy, but please make sure you make preliminary submissions as the sentencing guidelines, and if you're prosecuting, and make sure that any ancillary orders which you are going to be seeking have been uploaded in advance so that the defence have had an opportunity to consider them. And secondly, and really importantly for all of us, please familiarise yourself with the section of the code that will apply to your hearing so that procedural errors don't happen. No one wants sentences to be unlawful, but if everyone's following the code, then hopefully between counsel and the judges, we will eliminate that. I'm now going to pass you back to John, who's going to deal with any questions that may have been posed.
Thank you, Judge. Thank you, Amy. Both very, very informative. I think, Judge, as you were just going through your section there, you've answered one of the questions that came up, but I think Amy might have a little bit more detail, which is what is the interplay with the Act and the sentencing guidelines? Do the guidelines still apply? You've already said quite clearly that they do. Amy, where can we find that in the Sentencing Act?
Oh, it's sections 59 to 62 of the Sentencing Act. It also, and this is an example of this clean sweep, it makes clear that the court must follow the sentencing guidelines, whereas in historical cases, sometimes you were dealing with earlier law where the court simply had to have regard to them. Now, in all cases, it's the sentencing code, and the sentencing code says that the court must follow the guideline.
There was one earlier question that related to my first slide, I think. The question was, what is ETE? It's education, training and employment. There are a couple of other people who've clicked the hands up button. I don't know whether they want to type their questions so that we can answer them. I don't think we have a facility. Oh, maybe we're going to invite them in. Or not. If anybody has any questions, would you type them into the chat function, and we'll do our best to answer them. Or Ellie, I think you've been given authority to talk if you want to unmute yourself. Not sure we're going to get very far. There's a, oh, here we are, there's a question here. Will we get the notes and recording? The recording will be put out on our YouTube channel. As to the notes, can we get back to you on that? I've seen who's asked the question, I can let you know. I suspect that I can't see any particular difficulty with that unless anybody objects. Fabulous. Well, I think we will wrap it up. We're creeping up to an hour. We're not getting very far with... no, we're not. I thought we might just have a question coming in, but we haven't. Thank you very much, everyone, for attending. I hope you found this informative and interesting. Thank you very much again to Judge Connell for taking time out to come and join us. Thanks again to the LCCSA for helping us to promote this. We wish you all a very good evening. Thank you very much.